On the 14th of March 2023, Justyna Wydrzyńska, Polish feminist and abortion activist, was sentenced to 8 months of social work as a result of her conviction for an intent to aid an abortion. It was the first case in Europe when an activist was sentenced for this type of crime, so not a member of a medical profession, not a family member, a perfect stranger. The facts of the case were simple enough. In February 2020, Wydrzyńska, who is a well-known public figure, was contacted by a person in a very hard personal situation who was pregnant and was seeking medical abortion. Wydrzyńska, who had in her possession abortion pills, made them available to this person. However, the pills were not used. The woman seeking abortion had a partner who reported her to the police. The pills were confiscated. Nonetheless, Wydrzyńska was accused of the crime and was sentenced despite the crime not having taken place. The case was covered extensively by international media. There are many analyses of the legal, psychological, and sociological aspects of it. So let me just with this episode add one voice to this plethora of opinions. The fact that it was an activist that was targeted in this case was frequently represented as the edge-breaking quality of it. And of course, it stands to reason that activists should not be immune to criminal prosecution. Indeed, those who actively and overtly challenge the legal systems of their countries may expect the states to push back against them. However, it is not the way of law-abiding democracies to push back harder against those who are more vocal in challenging the laws. So in many ways, Wydrzyńska's case was a showcase. But what is also interesting is that this was a showcase not just for the situation of abortion and feminist activists in Poland, it was also a showcase demonstrating the role of a courtroom in Poland and beyond. Recent years have provided us with a number of examples of how courtroom becomes a place where the meaning of the basic values and rights and liberties is negotiated. Apart from Wydrzyńska's case, these causes célèbres, these very celebrated cases, include the case of historians who were being privately sued for defamation of a family member of one of the protagonists of their story about the Shoah or the Holocaust in Poland. They also included artists being accused of the offense to religious sentiments, and also lawsuits by the members of the LGBTQI community who felt defamed and offended by the statements by the public personages. What connects all these and many other cases is not just the clash of values represented and advocated by the national conservative government of Poland with other value attitudes in Polish society. It is also the fact that the courtroom becomes a place to decide meanings. People come there seeking justice, however they define it, and they argue about basically semantics. In one of the previous episodes, I covered the role of constitutional courts and how the argument about law before the constitutional court is, if you like, the highest form of a legal debate. Of course, ordinary courts, the courts for ordinary human beings like you and I, are different. People come there in their individual interests. They are seeking justice for themselves. But it is not as individual as that. At the same time, these people stand there in the courtroom as representatives of social categories. And in the case of Wydrzyńska, the social category for which she stood were women. Not feminists, not abortion activists, women, because this case, as it was discursively worked upon in the courtroom and beyond in the discourses around the case worldwide, was in fact a case of state versus Polish women, or by whatever Americanized name this case could go down in the annals of lawfare. In this case, these were women as a social category, standing before the court, and red lines were being drawn where their solidarity should end, according to the laws of the country.